Looks like most everybody's ready. Okay, I'm going to summarize what the court's understanding is, how this will be argued. It's the court's understanding that Mr. Harris will argue first, and is that correct? And then amici Stephen Locher will argue, and then it'll be 15 and 5, and then Mr. Miller will have 15, and then Ms. Beattie will have 5, and then we'll circle back with Mr. Harrison again, or Mr. Harris for 5. Is that correct? Yes, sir. Okay, thank you. Let's do a quick sound check. We'll start with Mr. Miller. If you check your microphone, we'll make sure Justice Appel can hear.
Yes, good morning. Testing.
Thank you very much, Counsel.
And Ms. Beattie, let's try yours too.
Good morning. Can you hear me?
Good morning, Counsel. Thank you.
Thank you.
And then we'll move to Mr. Locher so we can end with Mr. Harris. Mr. Locher, is yours working?
Testing 1, 2, 3.
Thank you. And did that work?
Yes, it did.
Okay, thank you. All right. Mr. Harris, we'll end with you. If your sound system works, then you can begin.
Yes, testing 1, 2, 3.
Working fine, Counsel. Thank you.
Thank you, Your Honor.
Thank you.
May it please the court, I am Steve Harris, here representing Xenia Rural Water District. Certified questions 1 and 2 largely address the before and after of the 2014 amendment to 357A.2. I think that the analysis, particularly with respect to the before 2014, needs to focus on the amendments that occurred in 1992. In 1992, the legislature changed the 1987 2-mile rule in a rather dramatic fashion, in my view. They first eliminated the arbitration provisions and submissions of the plan in the sentence regarding the 2-mile rule, and they added what I think is pivotal to this case, and they provide that the 2-mile rule applies except as provided in this section. They also added the words new area in connection with this process associated with providing service within the 2-mile area. The except as provided, of course, is exclusionary, and you have to look at 357A.2 in order to determine what is provided before there's ever any consideration of the 2-mile rule. And the statute as a whole at that point provided for the creation of a water district. The only restrictions on the Board of Supervisors creating this water district was that the district couldn't be within the boundaries of another district, and the area couldn't be in an area served by municipal water mains. That was it. There were no city limits limitation regarding what the Board of Supervisors can do, and of course, that's exactly what they did. They addressed a very large geographic area, and then they simply said, excluding the city limits of any of the cities that are within that area. That provided a distinct inside and outside line of demarcation. This, in my view, placed the 2-mile rule under the new exception, placed it outside the boundaries established by the CBOS. And that only makes sense based upon water district planning, because in knowing where your boundaries are and where you can provide water service really shouldn't be a doubt. Water districts might spend millions of dollars establishing a water tower or a pump station designed to provide water service that might extend 10 miles out from the location of that water tower. They need to be able to recover that investment, and that may span 20, 40 years, but they need to have certainty as to what their territory is, where they have the legal right to serve. The new area, the new words within the 1992 amendment, the so-called new area, also clearly indicates that that is a new area outside the boundaries of water district territory and within that 2-mile. Thus, it wouldn't make any sense otherwise when the legislature changed and adopted that word new area. Thus, it is the appellant, Xenia's position, that it does indeed have, based upon the 1992 amendments, did in fact have certainty as to where its territory was. It's squarely within all of the land that was designated by the Board of Supervisors, except municipality city limits that existed as of the time that order was issued in 1990. We then jump forward to 2014. we view the 2014 amendment, which adds the phrase or phraseology, extending service to new customers within existing service area, as merely a clarification associated with the 1992 amendment. Extending service is, in this context, based on the 1992 changes, was just an explanation if it wasn't already clear that the 2-mile area was outside the Board of Supervisors' designated territory for the district. If that wasn't completely clear, then they've added the phrase that this procedure relative to a new area to serve within 2 miles of a municipality was clearly outside those boundaries, because the whole concept of extending service is that you're going to make your system branch out and extend service in a very physical, mechanical way to new customers, customers not being served before, within what's called existing service area. Much of the argument in the briefing.
Counsel, do you need pipes in the ground to constitute an existing service area?
You do not.
Okay.
And the rationale and reasoning behind that is that a system has capacity. The district will plan, build a water tower or pump station, spend millions of dollars putting in that. But districts can't afford to put pipes in the ground until a customer arrives, holds up his hand and says, I would like to have service. Now, districts do plan 20 and 40 years down the road, as do municipalities. And they build these systems to meet that future demand. You can't have a demand and then build a water tower. It always works in reverse. You have to have the system capacity to meet that future demand, and most systems, municipal and water district, plan 20 years ahead, so they build today.
So doesn't the city have the same need for certainty? And what's left of the 2-mile, or their right to control areas within 2 miles of their city limits, if we accept your analysis?
I think that's incumbent in the initial stages of creating the water district to begin with. They have to publish notice. They're creating a territory. That's the opportunity for the city to object and say, hey, we don't think that's necessary, or we don't think that's appropriate. The creation of the district is dependent, and there must be a finding by the Board of Supervisors that the area proposed for the district is not being served by city water mains. That's the essential criteria for the creation of the district. The municipality can't just, have this district build systems designed to go right up to the boundaries and then later on wave their hand and say, we've changed our mind. We would like to serve that area also. Now, of course, there is no rights of exclusivity that I'm aware of under Iowa state law. And that's where 1926B comes to play and creates this right of exclusivity, a federal sanctioned monopoly that is derived from what...
But are you using that as a sword or a shield here? If you want to expand and put new pipes into the ground into a new area, does the federal statute let you trump the city's ability to control an untouched area within 2 miles?
The facts in this case show that Xenia is only using it defensively as a shield, not as a sword. And the reason behind that is that the Eighth Circuit in the City of Lebanon case adopted the reasoning of the Sixth Circuit in the Liax case. A careful reading of the Liax case will tell you exactly where the line of demarcation is. Liax bluntly says, if a state water district's, if a water district in the state, if its service area, geographic area, is defined by state law, which in Iowa it is, then that area is defensive. You are protecting and shielding that area as described by the Board of Supervisors. However, the rule is just the reverse. If it's outside your geographic boundaries established by state law, then you would be using 1926B as a sword, which under Sixth Circuit and Eighth Circuit law is not allowed. Here, we are clearly, in fact...
Setting aside the federal statute for a minute, explain to me just as a practical matter how these disputes get resolved under state law when you have a city that's growing and annexing more land and maybe growing into what would be Xenia's district. So how does that get resolved?
Well, I think in terms of the statute, particularly 357A, if the city annexes area, that doesn't preclude them providing service. The last line, I think it's section 5 of 357A.5, simply says, if the city annexes the area, it can provide service. The flip side is that if the water district also wants to serve that area, it would be permitted to. The only restriction against water districts from serving any area, because they can serve both inside and outside of their designated territory, would be the 2-mile restriction. And even there, the method of resolving the dispute as to who's going to serve is already in the statute. The water district says, relative to this 2-mile area, we're within 2 miles of the city, it's outside of our boundaries, which we have the legal right to provide service, both inside and out. We submit a plan to them. They've got a clock that starts, and within 3 years, they've got to provide service. If they haven't actually provided service by that time, it flips back to the water district. So there is a state law mechanism to resolve this for areas outside the district's designated area. But even for areas inside the BCO, the Board of Supervisors description, the city annexes it. The city, without federal protection, without this exclusivity, the city could also serve that area. And so I suppose at that point it becomes a race as to who gets to the customer first and provides the water under state law.
Structurally, what kind of bothers me about the position of Xenia here is that it seems this one resolution by the Polk County Board of Supervisors can kind of override the whole state law and this whole mechanism of a kind of 2-mile buffer area. And that just seems, kind of in the hierarchy of government, kind of unusual that in effect, the Board of Supervisors overrides state law. Am I making any sense? Or what am I missing?
I think the supervisors are creating an area where the district has the legal right of boundaries, perhaps political boundaries, because once you have those boundaries, you've got voters that are inside and people that are on the outside are not voting to control or regulate that. But Board of Supervisors, just like county commissioners or other legislative or administrative authorities, districts traditionally amongst all the 50 states have defined boundaries. The rare exception in Iowa is that if you have a 504A nonprofit organization or association, it has no boundaries. There's no one there to define that. There is the restriction that first appears in 2014 that relates to the 2-mile rule relative to associations. But prior to that, there's no law, no case authority, nothing that would restrict a water district from.
You have these 5 supervisors by a vote in 1990 somehow, and obviously Johnston's grown a whole lot since then, somehow sort of set the path for the future, and in effect this sort of flexible mechanism 357A that is set up by the legislature never gets to take effect under the system. That just seems, again, structurally a little odd.
Well, I think structurally, I might draw a parallel by Oklahoma, because in Oklahoma, it literally is the Wild West. Water districts serve everywhere. Municipalities serve everywhere. They trample on top of each other. And the only thing that generally separates them in Oklahoma is 1926B. That plays a role here as well, because once the district became federally indebted in 1982, the circumstances changed and federal law has crawled into this case. Not so much relative to the interpretation of the statute, with one exception. And I think that's noted. It's a decision cited by the amicus brief by Mr. Locher. And that is that the court should at least be mindful when interpreting an ambiguous statute. And I don't suggest that 357A is ambiguous. I think it's clearly worded and then later clarified in 2014. But the amicus brief points out that if through the process of interpreting a state statute that we're going to be on a collision path, a supremacy clause issue, a preemption issue with a federal statute, that some effort needs to be undertaken to make sure that collision doesn't occur. Our interpretation of the statute, which we urge the court to adopt, is that if Xenia has the legal right to serve within its boundaries established by Board of Supervisors, there isn't any conflict with federal law here that needs to be resolved.
What's the legal significance of Xenia's agreement that appeared to honor the 2-mile rule with regard to this naval facility?
One, that agreement is now expired, but two, yes, the agreement was signed, and it seemed to suggest that Xenia was acknowledging some restriction on the 2-mile rule. Xenia's misinterpretation of what the law was at that point in time would not be controlling on anybody, particularly Xenia. There's no concept of estoppel associated with how we're going to interpret a state law. How people think that that law might be, in my view, should not influence the court. The court's going to look at the words of the statute, apply the usual rules of construction, and come up with its own conclusion as to what that means. So I associate and attach no weight to Xenia's mistake regarding its misreading of the statute and whether or not that restriction applied.
Is it irrelevant whether, when Xenia was organized under the nonprofit statute 504, whether it had unlimited territory? If once it converted by operation of law, isn't it now bound by the restrictions in Iowa Code Chapter 357?
Well, when Xenia achieved dual status in 1990, that dual status, according to the Eighth Circuit's interpretation of the statute here, created dual status. The Eighth Circuit looked at it, and in that context and involving those facts, the Water District was actually formed after, or the Water District was converted after 1991. And at that point, the 1991 amendment created this obligatory dissolution. But for districts and associations that went through this transition process before 1991, and since the statute was not made retroactive, they achieved dual status. The application of the 2-mile rule only comes to play regarding this dual status, the nonprofit, when we see the amendment in 2014, that then, for the first time, applies that 2-mile rule to the association, the nonprofit, for the first time. But I would point the court to the words, that limitation. That would be service provided as of July 1, 2014. The dictionary defines the word provided as made available.
You can wrap up.
Yes.
Chief, may I ask one clarifying question? So, clarify this again for me. I want to come back to this to make sure I understand exactly what you're arguing. At the time the Polk County Board of Supervisors created the district, it excluded from the district those parts falling in within city limits.
That's correct.
And is that static? In other words, that district becomes fixed at that time? Or is it dynamic, meaning that as the cities continue to grow and annex land, the service area for Xenia necessarily becomes smaller?
It does not. Those boundaries become static. Obviously, someone can de-annex under the statute and remove area by going back to the Board of Supervisors. You could also add territory. You could also join territory from another district. But in terms of just municipal growth and annexation and going into the boundaries of Xenia, no, that doesn't create any change.
So at that point, your position is the growing municipality and Xenia both have equal rights to provide water services to those overlapping areas?
That's correct.
Okay, thank you. In the absence of 1926B?
That's correct, because 1926B changes everything, but that's an issue for the U.S. District Court to resolve down the road. Thank you.
I do want the record to reflect, I didn't mention it, that Mr. Smith, Frank Smith, is here, I believe. Thank you. And he is the Iowa attorney for Mr. Harris from
Yes,
Oklahoma.
I
Okay,
apologize.
thank you. Mr. Locher?
Thank you, Your Honor. May it please the court. Steve Locher on behalf of Amici Cure, Association of Regional Water Organizations, Iowa Regional Utilities Association, and Iowa Lakes Regional Water. I know it is rare for Amici to have the opportunity to participate in oral argument, and I want the court to know how much we appreciate being given the chance to do so here. As our interest and involvement in the case hopefully demonstrates, the implication of the court's interpretation of 357A.2 will have far-reaching effects well beyond the parties, immediate parties to the case. And in fact, there will be effects for rural water organizations and cities in every corner of the state. The reason the impact will be so widespread has to do with the background and economics of rural water organizations. Rural water organizations come into existence primarily to serve areas that cities do not want to serve, meaning primarily rural, low population density areas. And when I say the cities don't want to serve those areas, I don't mean that as a criticism. It's just an economic reality that you have to build a lot of infrastructure, spend a lot of money to provide water service for a very small number of customers. So the return on investment is very low, and it makes sense that cities wouldn't want to serve those areas. What happens, though, is as population centers in the state expand, and as some of those low population density areas start to become higher population density areas, suddenly the cities become more interested in serving them. And again, that's an economic reality and it makes sense. From the rural water organization's perspective, though, they have invested all that money in infrastructure, anticipating that they are going to continue serving those areas, including new customers in those areas, many years down the road. And that's where the problems start to come into play. Federal law for a long time has stood as a bulwark against cities using annexation to deprive rural water organizations of the ability to achieve an appropriate return on their investment. 1926B in particular has been consistently interpreted for that purpose and as recognizing the importance and significance of rural water districts' rights.
But do you need pipes in the ground to have the federal protection, as well as, of course, the federal loan money?
You need to have the ability to provide service to new customers within a reasonable amount of time. So pipes in the ground matters to some degree, but if you've got pipes adjacent to the new territory, then that still would be federally protected. We submit that, particularly as clarified in the 2014 amendments to 357A.2, the Iowa legislature has made clear that it wanted to ensure protection for rural water organizations as well. That's why, when the 2014 amendments happened, the legislature made clear that the 2-mile rule and the notice of intent process shall not apply in the case of a district or association extending service to new customers or improving existing facilities within existing district or association service areas or existing district or association agreements. Now, I want to make clear, even under our interpretation of that amendment, the 2-mile rule is not superfluous. It still has an important role to play. In fact, there are a lot of areas in the state of Iowa that are within 2 miles of a city and are not part of a rural water district, including areas as of 1990 within 2 miles of the city of Johnston. So if a rural water district were to try to expand into that area, the 2-mile rule could indeed play a role, and the notice of intent process would have to be followed. What the 2-mile rule can't do, though, is deprive water organizations of the ability to serve new customers within the existing service areas. And in that respect, although sometimes the federal case law talks about sword and shield effect of 1926B, I think it's important, as used by the Iowa legislature, to focus on the words new customers. Clearly, there was a recognition that...
Counsel, if I can interrupt, I'm sorry, I'm having trouble hearing you. Can you stand a little closer to the microphone?
I'll sure
Thank
try. And maybe if we put it up on the podium, it'll help. When the Iowa legislature chose to talk about new customers in the 2014 amendments, the legislature was making clear that rural water organization was not locked in time as to who it's entitled to serve. Instead, if there are new customers, new developments, new homes within existing developments, whatever it may be, if the rural water organization already has that service area, it gets to provide service to those new customers within that area as well. And
But, I
again,
mean, if you look at the word service area, that seems to me to connote some concept of pipes in the ground. I mean, if I'm driving along on the highway and I pick up my my phone to make a call and it doesn't work, I would say, well, I'm not in the service area, I guess. even though they might be legally authorized to serve me. I mean, isn't that sort of a plain English interpretation of that term?
It would be, but in order to adopt that as the interpretation of 357A2 subsection 4A, you would have to ignore the language of 357A.2 subsection 2A, which talks about the creation of a rural water district and emphasizes that at the time of its creation, the rural water district has to identify the, quote, area to be served. And of course, at the time of creation, there are not going to be pipes in the ground everywhere in that area. And yet, the legislature still chose to use the words area to be served. And so in the context of the very same statute, and I know I'm out of time, so I'll wrap up with this, but when in the context of the very same statute, you see the words area to be served in reference to the future plans of the Rural Water Organization, the legislature then later chooses to use the words service area in a later section. I think the clear implication based on the words the legislature has chosen is that it meant those two things to be coextensive, to mean the same thing. So with that, I'll
Let me wrap
conclude.
up.
Thank you.
And I apologize, Justice Appel, the Amici's microphone is lower, so I'm going to ask Ms. Beattie when it's your turn to move your microphone up, if you would. Thank you. Mr. Miller.
Thank you, Your Honor. May it please the court. My name is Bill Miller. I'm here representing the city of Johnston, counsel, and clients, and others in the audience. When the Iowa legislature looked at the circumstances with respect to the relationship between cities and rural water districts, it's struck a delicate balance that it's tweaked or changed over time. However, that balance has worked for decades, including between Xenia and Johnston. Johnston attempted to pursue the model of 357A.2 in this case, and for its trouble was sued. In fact, in this case, the 2-mile rule in 357A.2 governs, and that should be confirmed by this court in answering the certified questions posed by Judge Gritzner. As the court's aware, Xenia was reorganized in 1990 as a district pursuant to the Polk County Board of Supervisors resolution, quote, with all the rights, powers, and duties specified in section 357A.2 of the Code of Iowa as amended. So earlier, Justice Mansfield asked a question with respect to the dynamic between the Board of Supervisors, the cities, and the like. Well, respectfully, that's not even the case here. The Board of Supervisors acknowledged Iowa Code section 357A.2 existed, incorporated it in its own resolution. There was no even overriding of that process under the circumstances of this case. Later in time, or at that time, in 1992, Xenia gave up its prior nonprofit form. It chose to reincorporate as a district. As you'll see in 357A.2, there is distinction in the language between district and association. I believe there's some argument from Mr. Harris about the water services provided as of July 1, 2014. I just note that sentence relates specifically to associations, and Xenia is in fact a district.
Do they have a dual status, as we just heard about, or can you have it both ways and have the benefits of each corporate function, or do you give up the 504 when you convert to a 357 entity?
Well, we believe it's clear they gave up that function. And we think that that would be derived from Iowa law, but even more specifically, their resolution choosing to become a district, not the Polk County resolution, but the work they did on the back end within Xenia, they chose when their board voted to become a district to relinquish their nonprofit status. So the dual status concept simply has no basis. Ultimately, as well, even if there's a dual status, it doesn't get them anywhere. They claim without authority that they have a broad power to provide water service wherever they'd like at the time. If you go back to the 1977 Code of Iowa, this concept of the 2-mile or of the district coming and requesting, or the association requesting service, was already in the law. And further, there's other provisions of Iowa law that clearly would have had to have been considered. Iowa Code Chapter 364 would give broad powers to a city to provide service, water service at the time. There's benefited water districts and other concepts as well. So
Let me kind of ask you to pick up where Mr. Locher left off. Does service area, does that mean the area that the rural water district is actually providing some service to, or does it mean the area they are legally potentially authorized to serve?
it must be where they're actually providing service to. I mean, the code is set up with a situation with 357A specifically incorporated in this case, that's going to be the process for them to determine within their 2-mile area whether they have the right to serve. So the concept or the approach Xenia and the amici want to adopt is basically ignore 357A.2. We have the rights to serve wherever we want. The Board of Supervisors said it. Ignore the fact they incorporated 357A.2. The fact of the matter is that their concept writes out the law, and that's not how we should proceed. There needs to be actual service.
But they're allowed to add new customers. So what, can that be new customers beyond the reach of the existing pipe in the ground? They put a longer pipe in the ground into a new area.
Well, respectfully, we disagree with their interpretation of that provision, and we're attacked and argued that the city is the one reading out the statute. But it's clear there's circumstances where existing customers may be receiving services. There's provision in the statute that says services before 1987. There's circumstances where a city and a district may have
But isn't Justice Waterman correct? I mean, under 357A2, they can add new customers within an existing service area. When they do that, they may well have to extend the pipes, right?
Well, that's possible, Your Honor, but again, that's an existing service area where they're actually providing service either because it predated the time frame or it occurred because a city may have waived that right and given them the right to serve that area. Perhaps they're extending on that. Or there's a prior agreement that they reached with the city for service within that area. I believe, or it seems that the legislature maybe acknowledged that in those circumstances where the parties have already worked with each other under 357A.2, rather than going back to the till and talking about adding a couple people on the line, for instance, we're going to allow them to go ahead and add those. But that's what we believe was happening in that circumstance. It doesn't write out 357A.2 or the 2-mile rule.
What are the practical consequences to people who live outside of city limits but within the 2-mile rule? What's the practical significance to the outcome of this turf battle?
Well, in this particular circumstance, it's going to be quite significant because the apparent remedy that's sought is that they're going to take over these customers and provide service to them and expect that the city provide them compensation for the folks that they've been serving, some for decades. So it probably wouldn't be overnight per se, but it would be a circumstance where people who have been within that 2-mile zone and been served by the city for years and years would wake up one morning with a new water service provider. And really, that question, Your Honor, really gets at the offensive versus defensive question here, too. The argument earlier was, well, we're not pursuing anything that we're not entitled to, but in fact, they're seeking to lop off a section of customers that have been receiving services from Johnston for years and years. It's clear that the beginning and end here is Iowa Code Section 357A.2, and that's what Judge Gritzner has already recognized in his underlying ruling. It's important.
Can you shed light on why it seemed like his summary judgment ruling answered these questions, at least in part? Why did he then, after further proceedings, ask our court to decide these issues?
Your Honor, I'm not entirely sure. There certainly was a motion to reconsider filed after, and there were some additional proceedings, as you indicated. There was just additional proceedings, and I guess Judge Gritzner, I don't recall precisely if he articulated why, but he did ask the parties if perhaps he should seek some additional input, and we said certainly that would be within your prerogative.
Did the federal court answer, on summary judgment, decide the issues, the legal issues correctly?
Yes, yes, he did. I mean, his analysis and the order that's in the appendix, I think it's at page 324, quite frankly, went through and analyzed all these issues and dealt with them appropriately and dispatched with them. Now, we do have some issues with respect to here with the court, whether the 2014 amendment is retroactive. In fact, Judge Gritzner did encounter that, confirmed it would not have retroactive applicability. This court should confirm that in its answers to the certified questions as well. You know, the approach that Xenia wants to take here effectively would eliminate the 2-mile rule altogether, not just merely tweak it as the amendment may have done, in fact. There's also some issues raised, respectfully, I just wanted to touch on because I think it's a little bit nuanced, raised in the Xenia briefing with an issue of its 1982 loan. That's an issue that actually doesn't get referenced in the certified questions. We believe that that would be something that would be outside of your purview in this case, but even if it had been raised, there was no evidence that these areas that are in dispute were actually within the existing area, the service area that Xenia was providing. They haven't provided service to these customers, whether they are in the encroachment area, as was referred to below, or in the disputed area, which is out toward the annexed area. Similarly, there's an argument that Johnston had somehow waived some rights, and it's not entirely clear what that argument entails. There wasn't a significant argument in the briefing, and it should be deemed waived. It's clear Johnston has not waived any rights. Even if you look at the 1990 Polk County Board of Supervisors resolution, as Judge Gritzner acknowledged, it would have been very probable or likely that Johnston would have looked at that resolution at the time, seen that 357.8.2 was specifically carved out and assumed its rights were protected.
What weight or significance does the naval station agreement that Xenia entered into, does that provide us any guidance?
Well, it is the fourth, in my estimation at least, circumstance where Xenia has acknowledged 357.8.2. That was not largely explored below, although certainly that's in the record and something that Judge Gritzner considered as well. There was change of heart on the part of Xenia, perhaps, in 2018. And we have the argument that you should just ignore that or not consider that. I don't think that that's true. I'm not sure ultimately if it's going to be particularly relevant for the certified questions, but it's certainly an issue within this case. So on the first certified question, this court should confirm that prior to 2014, a district did not have a legal right to provide service to portions of an area described in the Polk County Board of Supervisors resolution when that area was within 2 miles of the city limits and the city did not waive its rights. Again, I think I've already covered the effect of the 2014 amendment on how the procedure would work, and it did not rework the entire 2-mile rule. Critically, the 2-mile rule is still in the statute. If the idea was to get rid of it or to jettison it completely, certainly the legislature knew how to do that, and it did not. There's also some arguments that there's some effect to be considered from Iowa Code Section 357.8.13 and .24. Neither section has any application in this case. It's again a circumstance where Xenia is trying to reach for other scenarios and work them in here. Subsection 13 has a reference to boundaries, but that's distinguishable from this existing service area concept. And subsection 24 involves exchanging of areas between districts, which is not even at issue in the case. And finally, just to wrap up with respect to the dual purpose idea, again, the idea that somehow that made a difference in this case is new here and is not a circumstance that has any bearing. They gave up those rights, and that should not have any effect in this case. So We respectfully ask that in considering the certified questions presented, you respond in a way that upholds 357A.2, the concepts Judge Grichner incorporated in his order and ruling already. The statute can easily be squared and explained. He's done it already, and it can be confirmed by this court. Thank you.
Thank you. Ms. Beattie?
Excuse me. Going to lean over Bill here. May it please the court. My name is Amy Beattie, and I'm here today on behalf of the Iowa League of Cities. The Iowa League of Cities is an association of more than 900 cities in the state of Iowa. The League has long provided advice to cities concerning municipal utilities, rural water, and annexation. The issues raised in this appeal affect the advice the League provides to Iowa cities, affects the development and projects being discussed or constructed by cities, and affects annexation decisions made at the local level, as well as by the Iowa's City Development Board that has final approval over many cities' annexations. I may be one of the few attorneys, one of the few among you who grew up on rural water supplied by a rural water district. When I was in middle school, my parents signed an easement with Southeast Polk Rural Water that meant our family of 7 no longer had to rely on the truckload of water that came to fill our well each week. That is the role of rural water. Whether it be organized as a district or an association, it's to supply water to Iowa residents who have no other way to obtain it. Unfortunately, that is not how today's rural water districts and associations see their role. The majority of my practice is representing Iowa cities, both large and small. I know firsthand that cities before 2014 consistently interpreted Iowa Code Section 357A.2 to apply the 2-mile rule. They followed the process for approval or waiver when the rural water district overlapped with the municipality's 2-mile limit, and the city had not waived its right to provide water to that area. They negotiated, just like Johnston and Xenia did in the agreement they were trying to reach. I work with several cities that have long-lasting agreements in place that have allowed them to grow. Ankeny's grown into what was the Southeast Polk Rural Water District. West Des Moines grown into Warren Water District because of the provisions in the Iowa Code, they negotiated and reached agreements that has allowed that growth. I've also seen the flip side of that with the position that is now being taken by the Xenia and the others, and the Amici. I recently had a small...
Can I raise a point of order? It's amici.
Amici,
It's Latin, not Italian.
I'm sorry. Amici. Thank you, Your Honor. I've recently seen the effect that their positions has had on a small city, where the small city in central Iowa annexed 93 acres. This is their first annexation in decades. And after that annexation, they received a letter from the Rural Water Association saying that they had no problem with the annexation, but that the association's right to serve the territory, they were claiming that ability to serve the territory, is based on the fact that they have the physical and fiscal ability to provide water supply services to that area, and that they have had them since the early 1980s. So they're taking the position that the code sections do not apply to them and not giving that city the ability to even negotiate with them. If the positions are to be followed, it renders the process, the 2014 language, and the 2-mile rule irrelevant. The Iowa League of Cities and others, such as the Iowa Association of Municipal Utilities, that worked so hard on the 2014 legislation would not and did not agree to the legislation making such a change. They requested that change because after the Rural Water System No. 1 versus City of Sioux Center case, rural water associations began taking the position that the 2-mile rule had no application to them. The league then proposed revisions to the law to make clear that it and the notice process applied to associations as well as districts. Xenia and the Beattie argue that, that the language approved in 2014 gives them the right to serve anywhere in their district or association, no matter whether it was in 2 miles or irrespective of any process set out in the code, making it unclear when the 2-mile rule would ever apply. Indeed, as mentioned, in application, they have been taking the position that it does not. Whether it be Huxley, Nevada, or Colfax, or Cedar Falls, or Johnston, the position of the districts and associations seemingly has been the same since the 2014 amendment.
I'd like to ask a question. Mr. Locher brought up the fact that your example when you were a child makes perfect sense. Nobody wanted to come out there, not so much they were mean-spirited, but it would cost a heck of a lot of money to do so. So the rural water districts had the infrastructure or were willing to, I guess, gamble in a sense, and they started reaching those areas of our state that cities could not do. So with that argument in mind, haven't some things, and don't they have an investment that at one time the city couldn't step up and the rural water districts did?
Absolutely, they do have an investment, and that's the reason that the code's set up in the way that it does. That it is. It puts a process in place then in the event that there is that overlapping of the areas that are within the city, within the 2 miles of the city and the district. And so we believe that wholeheartedly that having that process in place, making sure that those 2014 amendments are followed by the cities, are supportive of both the rural water districts and associations and definitely the cities, because it brings them to the table, makes them discuss things, and lays out a process for resolution of conflicts.
You may wrap up.
I see my time's up. The League of Cities respectfully requests that the court reach the same conclusion as Judge Gritzner did in his order, which clearly sets out the meaning and intent of the law. Thank you.
Thank you. Mr. Harris? I'd like to start right off with bouncing off of what I just asked. I guess I could ask Mr. Locher, but you're the guy that gets to do the reply. Why is the system that's in place right now not adequate for those 2 examples that I just talked about, where rural water was willing to expend the resources and the infrastructure, and now Johnston says, well, that's what our law is for. Can you help enlighten me on that?
Relative to the whole theory behind rural water districts and Iowa law creating an area to be served, is once that's established, the district then must plan decades in advance to meet that growing population. If the district is constrained regarding its legal right to provide service, as suggested by the municipality here, what you end up with is a system that has 1 customer per mile of pipe, and a system on that financial scenario will go broke, or it'll drive the price of water into the stratosphere, making it unaffordable for rural residents. It's called, in the parlance of 1926B, it's the economy of scale. So we create a territory in Iowa, and the district has the ability to grow into that area, and it must make millions of dollars of investments into the future. And these extending lines or extending service to new customers falls exactly within that. You build a 36-inch line that goes off as an 18-inch line, and eventually it gets to a farmhouse someplace as a 1.5-inch line. These lines are built for overcapacity, and therefore the whole concept behind extending service to new customers, the exact words in the statute in 357A2, extending that service is just part of the process and does not fall within the 2-mile rule by the explicit words of 357A. Now, the Municipal League's brief goes completely over the top by suggesting to this court that, okay, extending service to new customers can't involve new infrastructure. That is utterly nonsensical and must be rejected. I was astonished when I saw that in the League's brief. The whole concept behind extending service is you've got to make the pipe longer. Sometimes you have to add a pump station. Sometimes you have to increase the capacity of the water tower. But that's all part of the process of extending service to a new customer. And the whole thought regarding a new customer is that customer is somewhere beyond the current so-called pipes in the ground. Pipes in the
I
ground.
don't know, I live in Pleasant Valley, Iowa. There's a lot of development of what was farmland, and they put in a new street, and then there's some houses start popping up on spec builders or contract. But then there are gaps, and couldn't new customers simply be, all right, another house goes into this cul-de-sac here, and you run the 1.5-inch pipe out to that, there's your new customer, as opposed to a new farmland a mile down the road with no pipes in the ground. Is that outside the existing service area?
I think once you start defining existing service area as something other than the area to be served, the language in 357A, then you get into the problematic issue of, okay, I'm extending service to a new customer within the existing service area. Does that mean 1 block? Does that mean 1 mile? Does that mean 10 miles? It throws uncertainty relative to every new customer. Can the water district serve this new customer or these new 10 customers or the 100-house subdivision? It creates complete uncertainty.
Didn't the legislature choose to give the city some certainty within the 2 miles? If your company isn't already there with pipes in the ground, the city has effectively of some control over that 2-mile area.
I think that only assumes that the two-mile area overlaps the area designated by the Board of Supervisors. We maintain that the 2-mile rule only applies outside that area, and when it does, absolutely, the city has a certain rights associated with that. But inside the water district territory established by the Board of Supervisors, the answer is no. And I think that's clearly stated in the 1992 amendment that says the 2-mile rule, except as provided in this section, and this section provides for the creation of a territory called the area to be served, later in time called the existing service area. Those two terms mean the same thing, but they refer to 2 different temporal time periods. The area to be served is the designation to occur in the petition. Thereafter, an order is granted or a resolution is adopted. Once the resolution is adopted, that creates the existing service area. So that's the rationale.
And we have the last word on state law, answering certified questions, but how did Judge Gritzner rule on those issues?
He ruled against the water district on those issues.
Right.
Then and urged him to reconsider. He looked at those arguments and then took the dramatic step of saying, you know, I think I better get some guidance from this court in order to answer those questions. I think it's apparent from the granting a motion for summary judgment, motion to reconsider, and then the court issuing certified questions, seems clear that the federal district court lost confidence in its original interpretation of 357A and is seeking guidance here.
You may wrap up.
Thank you, Your Honor. The city proposes a interpretation of 357A that is not only nonsensical, but utterly unworkable, and does a great disservice to all of the rural water districts and nonprofit associations in the state of Iowa. We would urge the court to reject that interpretation and adopt what Xenia has presented and what Amicus has presented, namely that the area to be served is synonymous with and coterminous with the idea of an existing service area. Thank you.
Thank you. The case of Xenia Water District versus City of Johnston is hereby submitted. And the case of Iowa Supreme Court Attorney Disciplinary Board versus Whittiston is submitted without oral argument. Court is adjourned.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.